Hi, I'm David Mania, the Minister of Finance and Economic Opportunities in the Western Cape, and I'd like to welcome you all to this Cape Health Tech webinar. The health technology sector is an important sector for us in the Western Cape because it currently contributes an estimated 1.7 billion rand to the provincial economy and creates approximately 2,500 full-time jobs in the Western Cape. Around 40% of the top 10 Western Cape export markets for medical technology are in Africa, while Europe, the United States, and the United Kingdom are the top export markets for pharmaceuticals. And so it's no wonder that the Western Cape boasts a number of highly innovative digi-health companies. We have the overwhelming evidence that Cape Town is Africa's leading tech capital. Now we need to jointly tell the world. And it's for this reason that just last week we launched a unified tech brand for Cape Town and the Western Cape, officially positioning Cape Town and the Western Cape as Africa's tech capital. The initiative seeks to clearly represent the values, skills, talent, innovation, and lifestyle offered by the tech ecosystem of Cape Town and the Western Cape, and of course to showcase Cape Town as Africa's tech capital. This will attract international investment and funding, reinforce our brand to stimulate exports of our tech products and services, stimulate uptake of tech in our local industries, and of course raise awareness of the tech career opportunities for young people in the Western Cape. We invite the medical tech sector to join this collective and get the logo. For more information, visit westgrow.co.za. I thank you.
This past year has forced every business, sector, and individual to reimagine how they operate. So we're excited to welcome you to the first virtual version of Cape Health Tech Week. South Africa's pharma and medical device sectors are the largest and most advanced in sub-Saharan Africa, with pharmaceutical and medical device sales more than doubling in the last 10 years to reach 48 billion rand and 19 billion rand in 2019, respectively. The pharmaceuticals market in Africa is expected to grow to $45 billion in 2020 and more than 160 billion by 2024. This would represent a compound annual growth rate of more than 20%. In 2016, the Western Cape had 43 health technology firms, with 72% focused on medical technology and the remaining balance focused on pharma biologicals. It's no wonder that here, in the tip of Africa, the future of medical innovation is not only being imagined, it's also being created. And now COVID-19 has catapulted the tech sector, particularly the medical tech sector, to innovate more rapidly than ever before. With Cape Town already celebrated as Africa's tech capital, enabled by a dynamic ecosystem, we believe there's a real opportunity for innovation and future growth.
Hello and welcome to the third day of Cape Health Tech Business Week Virtual. In this session today, we're going to be discussing intellectual property and POPI regulations. We're joined today by three industry experts from ENS who will be providing an overview of IP protection and POPI regulations in South Africa, focusing specifically on health technology products. Just a reminder, if you have any questions during the session, please will you type them in the dedicated Q&A box at the bottom of your screen and not in the chat box, and we will answer them at the end of the presentations. I'm going to start by introducing our first two speakers for the sessions, Andre and Joanne. Andre specializes in commercial and transactional intellectual property matters and trademark prosecution, with a specific focus on IP aspects of the pharmaceutical industry. He also has experience in patents, domain name management and enforcement, IP licensing strategies, and antitrust and tax concerns around IP commercialization strategies. Dr. Joanne is a qualified patent attorney specializing in patent filing and prosecution in the biotech, pharmaceuticals, and chemical sector. She holds a PhD in medical microbiology and vaccine development. She has extensive experience in the field of biotechnology and life sciences, as well as in pharmaceutical and chemical inventions. Andre and Joanne, over to you.
Thank you very much for the introduction, Kendra. So I am just going to share my screen. Is it that one? Okay. Can everyone see my screen? Can I get a thumbs up from someone? Okay, cool. Okay, so thank you for the introduction. As you mentioned, we are going to talk about intellectual property in the sort of pharma and biotech space today at a very high level, and literally just sort of a rock skimming across the surface of what really plays a role in intellectual property when it comes to medical devices, pharma developments, biotech developments, and everything around it, the whole sort of life sciences space. I'm going to do a bit of an introduction to intellectual property, again at a very high level. Just talking about a few of the main types of intellectual property that you are likely to encounter in either your startup or ideally once you're successful with your massive business. I'll go into a bit more detail on one or two of them, and then I will touch very briefly on some of the regulatory aspects and how it's interwoven with IP. I know you've got a regulatory session this afternoon, so I'm not going to say too much about it. I'm more trying to show that link between those two aspects that you need to deal with. And then Joe will be talking about patent landscaping at the end of the presentation, which is very much the sort of kickoff of the whole sort of IP investigation into new products. And you'll see why we say that as the presentation goes on. There is a spot for questions at the end. Typically, I actually like to keep these discussions interactive, but I don't think it's going to work in today's sort of setup. So please leave your questions to the end or post them in the question box as suggested by Kendra. So we've already had a very nice introduction, so I get to skip a few of the slides. Joe and I both work for a law firm. It's a big law firm. You can read all about it there. Okay, so why should you care about IP and what difference does it make to your life in the pharma industry? I always like to start my presentations with this specific slide, and I'm not going to sort of, I can talk about it for hours, literally every slide I can talk about for hours, but I promise I won't. This slide represents the value of the sort of brick and mortar assets of companies versus their intellectual property assets on the S&P 500. And if you just look at this sort of the progression, it's from 1975 to 2020. And in 1975, about 17% of the S&P 500's total value was made up out of intellectual property assets. And that has absolutely shot up over the last however many years, up to a point where it's sitting at around about 90% at the moment. So that means if you go and look at the average in the S&P 500, you will find that 90% of their asset value actually sits in intellectual property assets. It's a massive number. And you may think that, yes, it's because the Facebooks and the Googles and all of those guys are on the S&P 500, and you won't be wrong. But I assure you, I've done this exercise for pharma companies, and on the ones that I investigated, most of their values sit somewhere between 85 and 90%. Make absolutely no mistake, the industry that you are playing in is an IP-driven industry, and your ultimate assets that you're going to be dealing with are intellectual property assets. That doesn't really matter how many factories you eventually put up or how many computers you buy for the people in your labs. Your true value will always sit in intellectual property assets. Okay, so what are your intellectual property assets? We broadly split them up into two categories. The first one is your statutory intellectual property assets, and the second one is what we call the non-statutory ones. And for those that don't like legal speak, statutory basically means that there's an act or a piece of legislation that governs that specific form of right, and non-statutory means there isn't a piece of legislation. So typically that's in what we call the common law, and the law that's sort of built up in the courts over time, sort of regulates how that's dealt with. Now, the statutory assets that you would deal with would include, for instance, trademarks, copyright, patents, registered designs, plant breeder rights, and domain names. Domain names is still a bit of a bastard child. Some people want it there, some people don't want it there, and that's also a completely different discussion. But those are the main things that you would encounter. And I'm going to talk a little bit about patents and trademarks in the rest of the presentation. I'm not going to touch on copyright, register designs, or plant breeder rights. That's not because they're not important. That's simply because I don't have enough time to talk about all of them. Each one of those are extremely important in the type of work that you guys do. We've done work for some of the biotech startups down in your part of the world where plant breeder rights is absolutely central to everything that they do. So each one of those rights really can be very important for you. Then the non-statutory ones, they tend to be the ones that are a little bit less focused on, and that is a big mistake. Please never, ever, ever make that mistake to think that you have a patent, so now all of a sudden you don't really need any other form of intellectual property right anymore. That's simply not true. How I always like to see this is that the statutory rights sort of make up the skeleton of the body of your IP assets, and the non-statutory rights sort of make up the sinew and the muscles and everything. Without them, the rest simply don't operate. You can't, to have a patent that's sort of written down on a paper, it's a certificate that you get. That's all it really is. To actually work that patent and to make that asset profitable for you as a business, you need the know-how that goes along with that patent. You need the confidential information. You need the trade secrets. So please don't ignore that part of your intellectual property asset base, either from a sort of description and use point of view, but also from a protection and valuation point of view. It's not unusual to find that the main forms or the most valuable forms of intellectual property rights in a business is actually those non-statutory ones. Not always the case, but often it comes up that some arbitrary recipe or know-how actually is the absolute sort of middle pint of that, of the rights of that business. Okay, so the one thing that I'm also going to do is, because we're flying through this presentation today, I've got about 2 or 3 little sort of golden nuggets that I'm going to drop in there, and I will give you a big red flag to say when I'm going to say one of those. So red flag alert, one of them is coming. It's extremely important for you to realize that these intellectual property rights exist in an ecosystem of rights. They don't exist on their own. Some of them can sort of function a little bit on their own, but typically a trademark can't really function without a copyright. As I said, a patent can't really operate without know-how or confidential information. And it's extremely important that you take away from today that this whole ecosystem of rights is a rights that you need to, number one, protect and maintain, but secondly, need to value and exploit as well. Otherwise, you're just sitting on an asset, and that's never a very good idea. Okay, so I just have a little picture here of some of the rights just to sort of drive home that point a little bit, to show you this ecosystem, how it exists in an actual pharmaceutical product. So I've just drawn random lines there and written things next to them, but I can tell you a story about each one of those, and each one of those are extremely important. And just to give you an example, for instance, if we look at the patent, there can be a patent on the actual capsule, there can be a patent on the active ingredient in the capsule, there can be a patent on the formulation in that capsule, literally hundreds of patents just on the tablet. But it doesn't stop there. There can actually be a patent on the packaging as well. Perhaps that's some form of tamper-proof little thing that can't open, and you can have a patent on that. So it's important that each one of these elements, again, so now we're going past the sort of technical stuff, and we're looking at everything around the product and the intellectual property rights around that product. Something like know-how, for instance. Obviously, there's a lot of technical know-how in the development of a pharmaceutical product, the manufacture, sourcing of raw material, all of those things are enormously important. But don't forget that there's actually know-how in the commercialization of that product as well. One of the examples that I've come across in my career was on baby formulations, or formulations for baby milk. If you go to the supermarket next time and you stand in front of the shelf with all of those different sort of baby milk formulations, do yourself a favor. There are 2 types there. The one is a scientific look and feel. It almost looks like a pharmaceutical. And the other one is a nice, warm and fluffy, motherly, comforting feel. That's a very, very deliberate strategy by the different milk producers. Some of them know that mothers who give baby milk to their babies like this sort of scientific-y, pharmaceutical type feel to the products because they want that trust. And the other ones more go towards a warm and fuzzy feel. So you'll find the one that has teddy bear. Okay, the regulations don't allow teddy bears, but used to have teddy bears and all sorts of things on it. And the other one would be very clinical. It almost looks like a prescription drug when you go and look at the packaging. That's a form of know-how, and that's a form that sort of drops, well, I guess rises above or drops below, depending on where you see your marketing department, the technical side of your product developments. And it's something that you absolutely cannot ignore, because it doesn't matter how great your product is, you ultimately need to sell that product. And hundreds of those type of examples in that slide alone. So talking about trademarks, important thing, a trademark can be virtually anything that can differentiate your product from someone else's product. The list that's on that slide there actually comes out of the South African Trademarks Act. It's a device shape, name, configuration, blah, 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 and all sorts of combinations of those. But I mean, it goes as far as the smell of freshly cut grass has been found to be a trademark for tennis balls. A little musical jingle can be a trademark. Any of those type of things can be trademarks. In the industry where you trade, it's quite heavily regulated on what you can use for your trademarks and what you can't use. So it plays quite a big role in what you do. It actually, you would think that the guidance that gets provided from a regulatory point of view makes your job easier, but it actually makes it more difficult, because you've got a third element to consider, where normal, sort of, if you were selling bottled water, you only really have to worry about the commercial and the legal aspects on your little Venn diagram for your trademark. If you're dealing with pharmaceuticals or medical devices, typically there's a regulatory angle that comes in as well, and actually quite seriously limits how you can sell those products and what you can describe them as. Different schedules make a difference. All of those things come into play. And okay, red flag, important thing. My favorite thing about trademarks, and I've got very many things that I like about trademarks, but the absolute favorite one is that the term is indefinite. Now, why that's actually so important is, if you go back to that slide on the different types of IP, for every form of statutory IP, there's a time limit on it. So a patent is 20 years, a design is 10 or 15 years. Every form, copyright depends on the type of copyright, is 50 years after you die, that type of thing. But each one of those rights come to an end at some stage. And that's the important sort of quid pro quo in intellectual property rights. You get this statutory monopoly for a certain time, and please don't use that word in front of my competition or antitrust colleagues. They don't see it as a monopoly. It's a right to exclude, if you really want to. Anyway, the point is, every one of those come to an end except the trademark right. So when the Coca-Cola guys thought up their trademark 150 years ago, wherever it was, they came up with that name, and they've just poured value into that asset over the time that it existed. If that were any other form of intellectual property right, it would have come to an end at some stage, and it would have become everyone's property. Not so with the trademark. And that's why it's so important that when you look at your trademarks for your new venture or your new product or whatever it is, you need to think about it very carefully and think about this long-term investment in the trademark. All these other rights that you have are going to sort of build your business. But what ultimately is going to be the value in 20 or 30 or 50 years is actually going to reside in the trademark, or the branding, or the goodwill, or however you want to describe it, the reputation. And all of those elements link back to the trademark. It's an extremely important asset for you to get right, get registered, and maintain properly. Okay, I have this slide in here just to give you a bit more information on trademark, and you can look at that at your leisure. Patents, slightly more technical than trademarks, depends on who you ask. If you ask Joe, it's way more technical. If you ask my trademark colleagues, it's sort of the same thing. The important thing is that with a patent, you actually protect an invention. And there are three things that you need to satisfy to get a valid patent. That's novelty, inventiveness, and application in trade. The third one is usually not that important. The other two are extremely important. And the one that I want to focus on, and my sort of main thing that I want to drop on patents, red flag, is the novelty element of a patent. If you disclose your invention prior to the filing date of your invention, you can't get a valid patent. If you publish it in a scientific journal, or you go out to your friends for a drink, or stand around a braai, and you're all based in the Cape Wineland, so I always see you having a braai in some lovely vineyard or something. If you're standing around that braai and disclosing your invention to them, you're destroying the novelty in your invention. And the knock-on effect of that is you can never, ever, 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 ever get a valid patent on that invention. So you're effectively destroying your own asset before it exists. it is crucial that you maintain the secrecy in those type of inventions of yours. There are ways that we can manage it with non-disclosure agreements and all sorts of things that we put in place. But the best way to maintain that is just don't tell anyone about it. Don't publish it in the scientific journal. Don't go and speak to some guy at the university about it. Keep it secret until you file that patent, please. The term of a patent is 20 years. You'll see I've got a big asterisk next to that one. That's because formally it's 20 years, but pharmaceutical companies have all sorts of clever ways and means to try and extend that 20 years beyond its life. Not on the patent specifically, but quite often on the product. And I've got a lovely presentation on patent evergreening tactics and things that I'll share with you at some stage, just so you understand what it is that they do and how they actually accomplish that, and why it's become such a vloekwoord, that swear word, sorry, patent evergreening or patent extension of life and everything, which it's bad, and civil society has really stood up, justifiably so, against some of the tactics of the pharmaceutical companies. But it's not always as clear-cut as it seems in the media or in emotive press releases. So it's a very interesting point that we want to speak about now. As I mentioned, I'm not going to talk about pharma-regulatory considerations a lot because you've got your presentation coming up this afternoon. What I did want to share with you on the pharma-regulatory side is this slide, which sort of attempts to overlap the intellectual property protections that you will be looking at on your regulatory timeline of your product development and ultimately your product launch. So the little white blocks there is just some of the stage gates that you're likely to encounter from a regulatory perspective when you develop a new product, a pharma product, take it through the registration process with SAPRA and ultimately launch it. And then I try to highlight a few of the IP considerations that would jump out as part of that process. Now, I've really considered this for a very long time and much more deeply than I think is entirely healthy. And unfortunately, there's no sort of paint by numbers version that will ever fit in where I can tell someone, okay, this is your product. At this stage, you need to do this. At this stage, you need to do that. It simply doesn't work that way. It can depend whether it's a generic product or an innovator product. It can depend whether it's a medical device. Even within those specific categories, my time's up. Even within those specific categories, there can be sort of tweaks and differences to it. But as a sort of very general high-level type of thing, you'll look at patents very early in the process, and you'll look at it throughout the entire process. But things like landscaping and freedom to operate searches and those type of things would be around about the R&D phase or very early in the phase. And when you actually start making your regulatory submissions, then a lot of the other type of rights would start coming in, things like trademarks, the copyright in the actual dossiers that you'll submit, all of those type of things. You'll see that I also have IP licenses there as part of this. Oh, I'm sorry, if it's not clear, that's a golden thread that weaves through your entire thing. That's at least what I tried. Mine came out green on my side. I don't know how it looks on yours. I have IP licenses there as well, which is an enormously important factor of your sort of product and your product developments and ultimately the launch of your products. Each one of those agreements that you enter into, whether it's with a raw material supplier, with a manufacturer, eventually with someone that commercializes your product, each one of those has an IP element to it, to the extent that a lot of those are pure IP-driven agreements. So a manufacturing agreement may, for instance, actually be a patent license where you license your patent and your know-how to a third party to manufacture on your behalf. The commercialization one may be one where you supply the products to them, obviously, but ultimately you license your trademarks and your know-how to them to go and exploit this product in the market on your behalf. And it really is an important thing that you need to consider. Okay, I'm going to hand over to Jo, and she's going to say some things about patent landscaping, which you'll see is that first little blocky there on the golden thread. It's very often when you start considering R&D, it's the first stop that you'll make along the way. Jo, over to you.
Thanks, Andre. Yeah, so as Andre said, patent landscaping is typically, I would advise, the very first thing that one should consider doing before you start any kind of endeavor, whether it be a sort of a science and research endeavor. You know, you would obviously, you'd do your literature searches, looking at scientific articles using the usual routes. But really, if you are looking at something which you're going to be commercializing, it's very, very important to do a landscaping search as well. And the reason for this is that, and this shocked me, I have to say, it turns out that around 80% of published science and technology information is in a patent document and not published anywhere else. So if you're only looking at your normal non-patent literature, you are missing out on a huge amount of just technical data. Next slide, please. So what is patent landscaping? So essentially what you're doing is very similar to a usual, article search, is you're using patent documents to do keyword searches. So it's an electronic searching using online data for published patents. And not only will you get that technical data, what's really useful is you get a lot of business and legal information data as well. And so when you're in a business, you can use this kind of information to manage your intellectual assets. You can use it to not only identify projects when you're starting off, but also figure out as you go down the line in terms of your projects, which avenues are maybe best to pursue and which avenues maybe you shouldn't be pursuing because perhaps there's too much competition out there. Where are there gaps that you can go into, that sort of thing. It also allows you to consider things like management and enforcement because you'll know who your competitors are, but you'll also know at what stage in technology a lot of the competitor research is at. And of course, it can also assist for decisions around financial investment because do you have something that really appears to be a sort of an innovative nugget here that you can really plug a lot of investment money into? Next slide, please. So I know this is very busy, but I'm just going to kind of highlight some of the things that you can identify when you're doing landscaping searches. And it's a good idea to do landscaping at the start of a project, but it's also very important to continue through the course of the project to do landscaping analysis, just to keep up with what's happening out there in terms of what competitors are doing. But also your projects may change over time. And so it's important to understand that as you change your product or your research, that you are keeping up to date with what's going on out there. So it allows you to identify what other people are doing. So what is the state of the art? You'll be able to tell from that whether what you're doing is really inventive and novel and also has a commercial use, because you'll be able to determine where there are gaps in the technology that is patented, where perhaps there are opportunities, but also tells you where perhaps there are issues, where there's perhaps a patent thicket and it may be a high risk to get into that particular type of technology. It can also be very useful in terms of finding opportunities where, for example, a patent hasn't been filed in your country. So one of the things Andre didn't mention is that patents are territorial. So you only get protection in countries where you have filed and have granted patents. And there are a huge number of patents out there that have not been filed in many territories. That technology is completely accessible and free for you to use in any jurisdiction where there hasn't been a patent. So you can either use it as is and commercialize it where there's no patents, or you can build on it and actually file your own patents on it. So that's really useful. And I think the take-home message, I'm not going to go through the rest of that slide, but the take-home message, if the only thing that you take away from what I've said about landscaping is this, is first of all, it's really useful to identify whether you have freedom to operate when you're starting off a project, and to identify where there are opportunities within a particular field to figure out where one can go, but also that there's a huge amount of information out there which may well be free to use in many jurisdictions that you can then leverage off of. And that can really, I guess, shorten the period of R&D for your business. Next slide, please. Obviously, you can request somebody like myself to do patent landscaping searches for you, and we would use quite elegant paid paid websites like Questel, PatSnap, those sorts of things. And they generate really nice reports, and very easy to understand analytics can be generated from that. But of course, you can do it yourself, and there are some free websites that you can go onto to do the searching yourself. It's basically a keyword search. And then Google also offers Google Patents, which is quite useful now. And then, as I say, it is obviously important to also do your literature search as well using the journals. And that's my presentation. Thanks.
Thank you, Andre and Joanne, for those insights. Intellectual property can have significant financial value, and therefore learning, first of all, what they are and how to protect them is obviously very important. So thank you. I would now like to introduce our third speaker for this morning, Raki, also from ENS, who is going to be talking to us about POPI. Now, Raki specializes in technology, data privacy, cybersecurity, electronic communications, outsourcing, information technology, advertising regulations, social media, and broadcasting. She has assisted clients in their ICT compliance requirements and has advised on legislation pertaining to TMT law, the Promotion of Access to Information Act, data privacy and protection legislation, and the Electronic Communications and Transactions Act. Over to you, Raki.
Thanks, everyone. Thanks, Kendra. I'm just checking if you can see my screen. Yes? No.
Not yet. You can just press the green share screen button at the bottom.
Let's try that. Is that better? Great. Perfect. Welcome, everyone, and thank you for joining us this morning. I'll try and be brief. There's a lot to say about POPI or POPIA. Just a quick note about that. When the Protection of Personal Information Act was first promulgated, everyone started calling it POPI because it was a really easy acronym. And then we got an information regulator that said that POPI reminds her of a very loose woman. So she really does not prefer that term. So we're trying to move towards POPIA or POPIA. You get really fun pronunciations of the word. But if I say POPI, it's just because of habit. So I mean the same law. So we're talking about the Protection of Personal Information Act. So you may or may not be familiar with it. If you're not, I'm so glad you're joining us here today because it's going to affect you. It affects everybody in South Africa. POPI was a law that came into force or was written into law in 2013. And it's had a very long period before it's actually come into effect. And during this year, during COVID and everything else, unexpectedly, the president announced that as of 1 July 2020, POPI will be law. So we all scrambled, not expecting it, but essentially we are in the grace period of 12 months. So all organizations in South Africa have 12 months within which to be compliant with POPI, and that takes us to 1 July 2021. So as you can imagine, getting compliant with POPI is actually a huge task, but that's where we come and help you to be compliant with POPI. So what is POPI and when does it apply? So POPI applies to the processing of personal information. And what I mean by those terms, I'll break it down in the next few slides. But the first step to understand if POPI applies to you and if it's a law that you need to comply with is to determine whether or not you are processing any type of personal information and you're making that information part of a record. And if you are doing that, are you domiciled in South Africa? And if you are not domiciled in South Africa, do you use processing means in South Africa to process personal information? So you may have heard the term GDPR, which is the General Data Protection Regulation that came into law in the European Union in about 2018. And unlike that piece of law, POPI doesn't have extraterritorial effect. So it only has an impact on you if you are processing personal information in South Africa. And if you're doing that, then yes, you will be having to comply with it. POPI doesn't apply to any processing for wholesale activities. So if I record, my plumber's details in my cell phone, I'm not expected to comply with POPI because technically I'm processing personal information. If information has been de-identified to such an extent that it cannot be re-identified, and this is where everybody's going to sit up, I think, because you may be doing this quite a bit in your business, then you don't have to comply with POPI. But I should just mention that de-identified and re-identified have special meanings in terms of the law. And insofar as you meet those definitions and information can be used in such a format that you can't tell who that information belongs to, then you don't have to comply with POPI. There are some other exemptions, but they're not really necessary for the discussion today. So I'm just going to move ahead. So what is this elusive personal information? The way it's been defined in law is that it actually means any information relating to an identifiable person. So we have a nuance in South African law here. An identifiable person in terms of POPI includes a natural person, so a living natural person, or an existing juristic person. We are one of the only countries in the world that has data privacy legislation that deals with personal information of juristic entities. So as you can imagine, we're still trying to grapple with what that means for us. But for now, it's just good to know that personal information can include that of a juristic entity. POPI provides a list of types of personal information, but this list is not a full list. It's just an idea, it's an example. It can include anything else that may develop over the years that could identify a person. So there's all sorts of things: your race, your gender, your social origin, your physical or mental health, which is particularly important for the conversation this morning, your financial employment history, any identifying number, that also gets to be quite important in the discussions that we have, biometric information, personal opinions and views, and so on and so on. Biometrics in terms of POPI has a very special meaning, and it includes any sort of physiological characteristics. So it could be your fingerprinting, your DNA, retinal scans, voice print recognitions. All of those elements include biometrics. Now you would have seen on this slide that I've sort of highlighted certain words in red, and that's very deliberate, and that's because those classes of information are called special personal information. And special personal information is an extra category of personal information. It's because this type of information is extremely sensitive. And if you will be processing special personal information, then in addition to the general obligations that you need to comply with under POPI, there are additional obligations as well. And I'll get to the next slides on what that might mean. But insofar as you may be thinking about what sort of personal information you are processing, health information does include special personal information. So I've used this word a few times in the last 10 minutes, but what is processing? So processing is any activity that you can possibly think of that you would want to do with personal information, whether you collect it, whether you record it, whether you organize it, whether you collate it, whether you store it, when you delete it, when you share it, anything that you can do with personal information will constitute processing. So just to quickly wrap up, insofar as you are collecting, processing, sharing, recording, using personal information, which is information that can identify any person, which includes natural persons or juristic persons, and you are domiciled in South Africa, then POPI applies to you. There are very few instances where I think POPI will not apply to you, because POPI applies in every facet of your organization. Internally, when you think about your own employees, externally, when you interact with customers, when you interact with suppliers. So almost every single organization in South Africa will have to be compliant with POPI. So who are the role players? Who are the people that we talk about when we talk about POPI? We talk about a data subject. This is the person about whom that personal information relates. We talk about a responsible party. This is the person that directs the means and the purpose for processing personal information. So I'm going to just take a very simple example. If I had to attend your premises at your, where you work, which doesn't really happen these days, I would be requested to sign in. So there would be a security guard as I enter, and they would ask me for my name, my surname, my contact number, whether I have a firearm, whether I'm carrying a laptop sometimes. They would maybe scan my license, write down my number plate. So this will be all information that you would collect. At that instance, I am your data subject. You, as the company who decided that this information needed to be collected, is the responsible party. The security company that you may have, contracted to conduct those services for you is an operator. So an operator is any third party who processes personal information on your behalf. So that security company would be an operator in that instance. And because you're taking information about my name, about my contact number, I mean, all that information on a license disk, you have no idea how much information is on there. Almost all of it would constitute personal information. So in just doing that small process, you as the responsible party would need to comply with POPI in the processing of personal information. As a responsible party, you are expected to appoint an information officer. By default, the information officer is the head of your organization, whether it's your CEO or any other type of title that you give to the head of your organization, that will be your information officer. The wording in POPI as read with PIA is the Promotion of Access to Information Act, and it needs to be considered when you look at this law. Suggests that you can authorize another person to be the information officer, but this matter is currently being debated with the information regulator because they've expressed some contrary views, and I'm not going to go into that whole debate. But for now, it's safe to say that the information officer is the head, and you have the opportunity to delegate certain responsibilities to deputy information officers. The regulator is the Information Regulator of South Africa. They took office in December 2018. The chairperson is Pansy Tlakula, and they've been heading, and they are the body that's going to be tasked with ensuring compliance with POPI. And what they've very, I think, effectively said to the public is that they are taking this very seriously, and they will want all organizations to be complying with POPI, even during this grace period. So if you're expecting that date, 1 July 2021, to be extended, think again. I think it's pretty much certain that this is here, it's going to stay, and it's very much needed law in South Africa. At the moment, we have very brief, sort of segregated pieces of legislation that deals with how, data subjects, consumers can be protected from over-processing of their personal information. And POPI seeks to, put in place those specific safeguards. I think I don't have enough time to go through all of this in a lot of detail, but it's safe to say that when you are going to be processing personal information, POPI requires that you comply with the 8 processing conditions. And these range from, on the slide, from accountability to further processing. So there are 8 of them that you need to comply with, and they deal with all sorts of things. The first is you have to be lawfully processing personal information at the time when you decide that you want to process it, right through the whole process of processing. The second condition is there's a processing limitation. So you must ensure that in your processing, you do so lawfully, you use the principle of minimality, and that you only process information, personal information, if you have a justification. The one that's most easy to rely on is consent, and consent in POPI has a very specific meaning. It needs to be the willful expression, and it must be informed and voluntary. So you have to meet those requirements in order to establish that you do have consent in order to process personal information. You also need to collect personal information for a specific purpose. And you can only use that information for that purpose. If you then want to use that information for another purpose, it must meet then condition 4. And there are certain sort of, guidelines on when you can use personal information for other purposes, and POPI lays those out in condition 4. Some of the other elements of the processing conditions are that you need to ensure that the information is of quality. So it needs to be complete, accurate, not misleading. And you also have an obligation to ensure that that information is updated. You have an obligation to notify your data subjects at the time of collecting their personal information of certain information. You must then also protect and secure the personal information that you collect. And you need to guard against any sort of, security compromise. In your security safeguard section, there's also elements around how you need to deal with operators. So in your interaction with third parties, you need to ensure you have a contract that stipulates how they can process personal information. There's also an obligation to report any kind of security compromise to the regulator, and data subjects have certain rights, and you need to ensure that they are given the appropriate tools in order to exercise those rights. I'm going to skim through this a little bit, so I'm going to skip to this slide. But one of the other things that POPI speaks to is direct marketing. We are currently in an opt-out regime. So before POPI, people could send you spam, and if you didn't want to receive it, you would opt out. But all it did was confirm that you were an active person, and so they would send you more spam. So what POPI does is it seeks to change that. So now you are only allowed to send direct marketing communications to people if they have opted in. And insofar as they've opted in, that means they've given you their consent to receiving it. And in each communication, you have to provide them with an opportunity to opt out, should they wish, or unsubscribe. And if you've asked someone for their permission in order to send them direct marketing communications, you can, and if they say no, you cannot contact them again. So you actually need to keep a list of people you've asked, ensure that, and if they've said no, then you cannot contact them again. If they've said yes, happy days, go ahead, send them all the spam you want. There is another justification you can rely on in order to send direct marketing communications. If they are an existing customer of yours, then you are allowed to send them these communications. But with all the communications that you send, you must ensure that you identify who the sender is, and you provide them with an opportunity to opt out. So that's a very high level understanding of what POPI says around direct marketing. Just a quick one, direct marketing only applies to any type of electronic communication. So insofar as you're sending pamphlets and you're emailing letters to people, or you're on the phone with them, that will not really constitute direct marketing in terms of POPI. And so then you'd have to consider, the CPA or ECTA and the like. Okay, I have 1 minute, and I think this is what's top of everybody's mind. What happens if I don't comply with POPI? Am I just going to, get away with it? Unlikely. So the information regulator has a lot of powers, and because POPI is very consumer facing, I have a feeling that consumers are not going to be taking this lying down. If you are not complying with POPI, they are going to lay complaints against you to the regulator. If we look at what's happening in the rest of the world and how the movement towards stronger data regulatory processes and monitoring of that, we can definitely see people are going to take an active role in ensuring that their personal information is protected. Never mind that, the regulator themselves can conduct investigations. They can do dawn raid type things where they come into your premises and they want to understand how are you processing personal information. And if you're found to be in breach of any of these things, then you could face a fine of up to 10 million rand if there's, for example, a data breach, or you could also face imprisonment. South African law likes to make criminals out of all of us, and the person that would be going to jail would be your information officer, like I mentioned, is your CEO. So it's something that you really need to take seriously. And that's me.
Thank you, Raki. POPI or POPIA regulations are obviously hugely topical at the moment due to that announcement by the president earlier this year. So it's very important that companies gain as much information as possible on what is expected of them in terms of the legislation. So thank you for helping to shed some light on that subject. Just a reminder to everybody that these sessions are recorded. So they are going to be put up on our site tomorrow. So if you didn't catch something, you will have an opportunity to listen again later and go through the information yourself. We have just a few minutes left now for some questions, which I'm going to open up to the floor. Just a reminder to please type your questions in the dedicated Q&A box at the bottom of the screen. And I think just to start things off, I have one question that I would like to ask you, Raki, is just where can companies or individuals go for more training on what is expected from them in terms of POPI?
Thanks, Kendra. That's quite great timing, actually. So Ian is hosting a number of workshops coming up in the next 2 weeks or so. If anyone would be interested in getting more information, please do feel free to send me an email or follow me on LinkedIn if you like, and I'll be posting, the registration for them. So we're having a number of sessions, one training on advertising and marketing and how to navigate that under POPI, and the other one is just a general understanding of POPI and how to comply.
Thank you. If you could maybe post those details into the chat for the entire session, that would be very useful. And then just to go back to our discussions on IP, one question, Andre and Joanne, for yourselves. Who should a company contact if they are looking for assistance on registering IP? And how do they go about that process?
I'll take that one, Joe. So they can obviously contact us. We have a dedicated intellectual property department that deals with the full spectrum of intellectual property, trademarks, patents, registered designs, commercialization of IP, and all of those type of things. But then also South Africa has some absolutely top shelf law firms that do this type of work. There aren't many of them, but the ones that are there are absolutely fantastic. So the obvious preference is that they contact us because we are the best. But if they prefer not to, there are some very good ones out there as well that they can contact.
And roughly how much time does it take to grant a patent? And are there any costs involved?
Yeah, so there's a process involved where you file what's known as a provisional application usually, and then within 12 months of filing the provisional, you would file either a complete South African application, which then gets granted, or if you wanted to go into foreign jurisdictions, you would file your foreign applications. And so the timelines differ depending on whether you're just filing a local application or whether you're filing foreign applications, and the prices differ dramatically. So for a provisional application, you're probably looking at, depending on whether you're an SMME or an individual, you're probably looking at between 18,000 Rand up to about 25,000 Rand plus VAT. A complete application is a little more, probably you could add another 4,000 or 5,000 Rand onto that. And then foreign applications can range anything from 20,000 Rand up to 120,000 Rand for example, the European regional system, which gives you protection in all of the regional countries if you validate. So it's quite a process which is quite flexible, and the costs and the timelines really differ depending on what you're looking to do. The South African patents will usually be granted within about 2 years of filing. And that's because at the moment there's no examination, there's no substantive examination. So that's basically just a formalistic process. And so you'll get granted rights within about 2 years. But in foreign jurisdictions where there's examination, it can take anything from 3 to 5 years to get a granted patent, assuming you succeed in getting it granted. And then there are some territories that are very slow, like India and Brazil, where it can take up to 10 years to actually get a granted patent.
And then a final question from my side. In which countries are South African patents recognized?
South African patents are recognized everywhere, but remember they're territorial. So a South African granted patent is only going to give you protection in South Africa. But if you file a South African provisional application as a priority application, that gives you the right to file in pretty much any other country in the world within 12 months. So, yeah.
Okay, thank you. Then if there aren't any other questions from the floor, oh wait, I do have one here. The question is, who governs the infringement on patents? What do I do if I suspect somebody is copying my IP?
So basically in South Africa, as I say, it's territorial. So I'm specifically going to talk about South Africa. So if you've got a patent that's been granted in South Africa and there's somebody that's infringing your patent, you would go to your patent attorney and you would tell them that you suspect somebody's infringing your patent. They would normally then do an analysis just to make sure that your patent really is granted. And we would also usually do an assessment to make sure that the claims of the patent are valid. So we don't have any skeletons in our closet before we try to go to court. The next process is usually that you would send a letter to the third party and you'd say, we have a patent, this is the patent number, here's a copy of our patent and our claims, you're infringing and please cease and desist. And then they will either, respond and you'll deal with it prior to the court proceedings, or after that process, you would actually go to court. And so in South Africa, the court that deals with patents is the Commissioner of Patents. It's a high court based in Gauteng. And initially there are there's paper-based litigation that happens first. There's usually probably 90% of the time, I would say, settlement out of court where there's an agreement between the parties before you actually even end up going to a hearing process. But then after that, obviously, there is the potential actual, court process where it's actually heard in court. I don't know if you want to add anything, Andre. You've also done some litigation.
Yeah, the only thing I would add is actually the last point that you raised, is that because of the technical nature of patent infringement matters, both parties tend to, how do I put this politely, not want to take the chance on the litigation because, as I say, it is so technical and it is so difficult to predict what the outcome would be. So most parties tend to settle, and depending on whether you're the patent owner or the infringer, we find that in almost all circumstances, there is some form of commercial solution to whatever the issue is, just to number one, dodge the litigation cost and uncertainty, but more importantly, actually to get a commercial outcome for both of the parties, which is ultimately why you're in business.
Thank you. That is unfortunately all we have time for today. But if you have any additional questions, please will you send them to us directly, and we can always direct them to the speakers and have them answered and sent to you later. Otherwise, just everybody, thank you so much for attending this Cape Health Tech Week session. And just a reminder to please join us at 2 o'clock this afternoon for a discussion with SAPRA on their regulations. Otherwise, to everybody, thank you and goodbye.